5 seconds. Start. The appellate court set aside the fine imposed upon the petitioner but maintained the compensation awarded to the LRs of the deceased and further directed that in case of non-payment of the compensation, the appellant petitioner herein shall have to suffer additional simple imprisonment for 6 months. The relevant facts leading to the prosecution and trial of the petitioner accused have been noticed by the learned trial court in para 2 of the judgment, and the same is reproduced below. On 22/10/1997, deceased had boarded Blue Line bus which was being driven by the accused Jitendra Kumar. At about 11 a.m., the bus reached at Ranjit Singh Road, and after crossing the red light, the bus stopped on zebra crossing due to traffic. Shaukat Ali started getting down from the bus from the front gate, and before he could completely alight from the bus, the accused moved his bus all of a sudden, and the said person fell down on the road from the bus, and the left rear wheel of the bus rolled over him. On noise being raised by the passengers, the bus was stopped and the driver ran away from the spot. The injured was removed to the hospital on the complaint of Chandra Pal Singh, who was on duty as ASI in traffic police. FIR was registered and accused was arrested. The accused was arrested next day after being produced by the owner of the bus. The learned trial court, after examining the evidence of two eyewitnesses, namely Constable Bhop Singh and Constable Yas Kumar, and accepting the same to be fully trustworthy, held the petitioner guilty for having caused the death of the deceased Shaukat Ali. In the appeal filed by the petitioner, the appellate court, after reappraisal of the prosecution evidence, also accepted the evidence of these two eyewitnesses to be reliable, and after rejecting the grounds of challenge put forth on behalf of the appellant, affirmed the conviction of the petitioner but order for payment of fine by the petitioner for his conviction under section 279 IPC was set aside since compensation had been awarded. On behalf of the petitioner, learned senior counsel has submitted that the case really being one of no evidence regarding rash and negligent driving of the bus by the petitioner, this court would be justified in exercising the revisional jurisdiction and interfering with the decisions of the courts below. He also submitted that merely on the basis of evidence of the so-called two eyewitnesses, it does not stand established that the accused was driving the bus involved in the accident, much less in a rash and negligent manner. The application under section 11 (c) of the Arbitration Act 1996 has been preferred, pleading that on 21st April 2007 an agreement was entered into between the parties where under the petitioner agreed to supply up of 1000 quantity of gift products vouchers to the respondent at MRP of rupees 10,000 each and at the barter value back in the air tickets of the respondent airline at 60%. A copy of the said agreement, which contains an arbitration clause, is filed along with the petition. It is further the case of the petitioner that, in pursuance to the agreement aforesaid, the petitioner supplied 850 gift vouchers of the value of rupees 85 lakh to the respondent, and under the terms and conditions of the agreement the petitioner became entitled to get back from the respondent the barter value in AR tickets worth rupees 11 lakh. However, the respondent gave credit to the petitioner of the value of rupees 32 lakh only, leaving the balance coupon credit of rupees 18 lakh, which the respondent avoided to give one pretext or the other.